Hey, y'all. Hey, happy, marvelous Monday, everybody. Thank you so much for joining me today. I'm super excited to share this conversation. Criminal records, our criminal screening policies, legal. That's what I'm going to cover today. And I see that I'm live on Facebook, I'm live on LinkedIn, and I'm live on YouTube. So thank you so much. All right, I see a comment here. Give me 1 second. All right, thank you so much. Listen, comments, remarks, questions, observations, please don't be a stranger. Show me some love in the comment section. Put it there. Again, I'm live on Facebook, I'm live on LinkedIn, and I'm live on YouTube. And so today's discussion is all about the criminal screening process that landlords put applicants through, and then having a conversation. Is it legal? Well, I'm going to talk about a story that happened out of Michigan, but this story is not isolated to just Michigan. There are a lot of situations, there are a lot of lawsuits popping up, whereas tenants are suing landlords or prospective landlords for not understanding the law. So again, although this situation is happening or has happened in Michigan, I want landlords throughout the United States to know and understand what the laws are and how you can prevent yourself from going down that rabbit hole. If you are a landlord, welcome. If you are a tenant, welcome. This segment is for the entire rental community. So I share information every Monday. I am live 7:30 p.m. Eastern Standard Time right here on this platform. And I do this because I like to bring about awareness and education to the rental community. So again, show me some love. Let me know where you're tuned in from. And if you have not already subscribed to my YouTube channel, please find me there at Landlord Life with Karissa Spann. There you can catch my replays. Make sure you hit that subscription bell so that you'll be the first to know when I am live and online. I promise to give out information today that is clear. Well, that's my goal, to make sure that it's clear, which is why if you have a question, please let me know what your questions are. Also, please know that I am not an attorney. I am not sharing legal advice. However, I am sharing the industry's best tips and practices. This is one of the things that I am passionate about doing. All right, so let me pull up my disclaimer because I want you to see it. I want to put it up on the screen. And then I'm going to get into the discussion today because I have a lot of information to share. And I promise if you stick around, for those of you who are landlords, I'm going to give you some tips. I have 3 tips for landlords, but also I have 3 tips for tenants as well. If you find this information helpful today, please make sure that you like, you tag, you share it with someone else. If you are watching the replay, put a 2 in the comment section. Let me know that you've seen it, you've heard the information, and I hope to share something that will positively impact somebody else's life. All right, so this is a true story I'm talking about today. This is a lawsuit that could have been prevented, but I want you to know and understand, if you had an opportunity to check out the description, the potential costs that a situation like this could, the range of what it could be. So anywhere from the range of 50,000, 500,000, even over $1 million for this type of mistake. One of the things that I always talk about are the costly mistakes, right? And so it is so important as a property owner, as a landlord, as a property manager, you must know the laws. If you are managing property for somebody else, please make sure that you educate yourself, because the laws don't really care about ignorance. Listen, ignorance is no excuse. It will, I promise that ignorance will not stop a lawsuit. All right. All right. I see your comments coming in. Thank you so much. Hello, Bishop. Thank you for jumping in. Bishop, I know that you know housing providers, landlords, please make sure that you get this information out to your colleagues, to your community, to those who are in your church, who are landlords. So let me get into the discussion today because I want you to hear this information. So again, the situation, it did happen in Michigan, but it's not isolated to just Michigan. Last week, the week prior, I shared stories and lawsuits that happened out of the Washington, D.C. area. And I'm touching on various jurisdictions because there are laws in place, right? The laws govern how you, as a landlord, as a property manager, as an owner, as an investor, how you must conduct your business. So these lawsuits are not just isolated to DC or Michigan or New York or California. The laws are in place all throughout the United States. So I hope that you're taking some notes on today. If you have questions on today, please make sure that you drop it in the comment section. So today I'm going to get right into it. And again, I have tips for those of you who are landlords. I have tips for those of you who are tenants as well. All right, so this pressing situation, just to give you a little bit of the backdrop, out of Rochester Hills, Michigan. And so here's a breakdown of the case. The Fair Housing Center of Metropolitan Detroit, they are a nonprofit organization. They advocate for housing equality. They are suing owners of a 126 unit affordable housing community. So that's 126 apartments, rental homes. And this apartment community, they, for whatever reason, they enforced a strict no felony convictions policy, which bars anybody with a felony record, regardless of the crime, regardless of how long ago it occurred, or the individual's rehabilitation from renting their units. And I know people are asking, well, Karissa, why is that a problem? We don't really want felons in the rental property. Well, according to the federal housing guidelines, rather, a blanket ban like this could definitely violate the Fair Housing Act. Now, let me just tell you that fair housing laws did come into play in 1968. Now, here's why it's important for people to understand fair housing laws. Fair housing laws came into play to prevent discrimination in housing. And so policies like this, it does have an impact. It negatively impacts Blacks, minorities, as well as Hispanic individuals who are statistically overrepresented in the criminal justice system. So you kind of see where I'm going with this? All right, but this is considered indirect discrimination according to fair housing laws, which again, like I said, it does have protection. It provides protection against these crazy fair housing practices that unfairly impact certain groups and category of people. And so usually when there's a fair housing complaint, one of the things that I always tell you is how it came about, what happened, what to look out for, what to avoid. So there are usually fair housing testers, okay? And that was the situation in this case. The Fair Housing Center, they conducted a mystery shop. So this is a test where they send out, testers usually operate in twos. They're not going to come together, right? So it may be someone who look like me. I may show up and say, hey, I'm interested in renting an apartment, or or maybe it's a conversation that go along these lines. Hey, I'm interested in getting an application for my brother who is a felon and he's returning home in a week, or maybe he has returned home and I'm looking for an apartment that might be suitable for him. And another person will go out with a similar story, similar situation, right? So we're looking for the same thing, but then the second tester is not going to look like me. It may not be a Black female. It may not be a Black American female. It may be a European. It may be a Caucasian. It may be an Asian male, right? But the story is going to be the same. The script is going to be the same. They're going to be looking for the identical type of unit. They're going to say practically the identical script from start to finish. So if you're a property manager and you get people who come in and they say the exact thing, the identical script, they're looking for the same size apartment, they tell you the same thing, please consider that it might be a tester. And this is one of the things that I teach my students how to do, how to mystery shop. So, but let me keep going. So these testers, they pose as a caseworker or a relative of potential tenants. And these testers, they mentioned felony convictions. Now, I know that many of you as housing providers, you are concerned. You should be conducting background screening, but you must also know the law when you are conducting these screenings. So each time the apartment staff encountered this tester, they reportedly denied applicants outright. They didn't give them a second chance. They didn't give them a second look. They did not give them an opportunity or any consideration, right? As a matter of fact, what they ended up doing was citing HUD or state restrictions, indicating that, oh, well, HUD prevents us from renting to a felon, or the state laws prevent us from renting to people with a felony record. Well, they learned a valuable lesson, because that is flat out not the case. All right. So the defense by the apartment community, the property owner claimed that they were following the rules from HUD and the Michigan State Housing Development Authority. Well, turns out that neither HUD nor the housing agency enforces such a blanket ban such as this. All right. And so the housing authority does allow rejection of applicants with felonies within the past 5 years, but it does not mandate a lifetime exclusion. See why this is important. See why you must know and understand the law. So let me just pause here. So let's just say that an applicant comes to rent your property, for those of you who are property managers or property owners, right? Let's say an applicant come, they have a conviction from 15 years ago. Maybe they have 2, 3, 4, 5 felonies from 15 years ago, right? You have to consider the timeline. You have to consider what the case was about. You have to also consider some other things. So I'm going to get into that in a little bit. So that was the argument of the owner, okay? It breaches the Michigan's Civil Rights Act and Persons with Disabilities Civil Rights Act due to disproportionate impact on people recovering from drug addictions. That means the laws, the states, the federal government, they are concerned. They want people who have been rehabilitated, people who have disabilities, to be able to find a place to call home. And just because they have a record from years ago, yeah, true, they do have a felony, right? But just because they have a felony, you have to look at, like I said, the time frame. You have to look at, there's some other factors that you must consider. Have they been rehabilitated? Did they go through some sort of rehabilitation program? And because this landlord did not know that law, they were slapped with this lawsuit. But let me keep going, because I want to get into the money. I want to get down to the money. All right. So this lawsuit, it does seek to end the no felonies policy, because you, as a housing provider, you can't just use a ban, a blanket ban across the board. That could violate laws. But now there are punitive damages against this owner. So here is what I want you to take away from this landlord's costly mistake. There are guidelines that are provided by federal government, state government, to advise landlords on how to conduct their rental property business. right? They should also know and understand that there's a ban on them operating their rental property business like this. They just cannot enforce a ban, and that they do recommend landlords and owners to consider the type of crime, the time that it happened, right? If there's a time elapsed since the conviction, those are things that the government want you to take into consideration. And if that applicant can provide evidence that they've been rehabilitated, that's something else that you must consider. Because although they are guilty of having committed a crime, they could be rehabilitated. They could have been renewed, right? They are a new person, in other words. They are not who they once were. They are not that person. And it's like when people are rejected from housing because of crimes they committed many, many years ago, it's like you're just convicting them all over again. And clearly, if there's some sort of change, that's not the case. So that's why it's important to know and understand the law. But now here, I want you to understand the risk for landlord, because, and then I want you to understand as a tenant that you do have rights. So I do have tips for you. But these blanket bans, they unfortunately do exist all throughout the United States. And some blanket bans may not be illegal under state or federal law. But here's the thing. It does leave owners and landlords vulnerable to lawsuits. So this is why it's so important to know the law, because the laws aim to reduce barriers for those who have a past conviction. The laws are in place to reduce barriers that would prevent people from getting into housing and affordable housing, right? And so I want you to really understand how important this is. Now, again, I'm going to get into the money, because I said that situations like this can cost in a range between $50,000 up to $1 million. And I'm going to break it down for you. So just stick around. I got some more information for you. So again, this did happen in Michigan, but here's what I do know. HUD has proposed in 2024 guidelines to tighten up restrictions, limiting criminal record. And like when you do these background checks and you're reviewing applicants' records, you have to consider convictions that have taken place within the past 3 years, right? And so some places are a little bit more, I would say, anywhere between the past 1, 3 to 5 years. Anything beyond 5 years, but definitely check the law. Don't go back any further than that, because you will open yourself as a property manager or an owner, you would open yourself up to potential lawsuits if you go back further than that. So, but here are some questions I want us to consider. Should landlords be required to consider individual circumstances instead of blanket bans? Just my first question. Let me repeat it. Should landlords be required to consider individual circumstances instead of blanket bans? Let me know your thoughts. Put it in the chat box for me. Here's my second question. How can landlords balance safety with fairness in tenant screening? So we're talking about balancing the safety, because I know that a lot of landlords, as they should, because if you've been tuning into me for a period of time, one of the things that I always say that is, if you treat your business like a business, it will pay you like a business. If you treat it like a hobby, it's going to pay you like a hobby. But I do have some tips for landlords I'm going to share with you on how you should conduct your rental business. But definitely be fair and be equal across the board. But here's the third question I have for landlords. What impact could this lawsuit have on housing policies in your community? So whether you're a landlord, whether you're just tuned in, whether you know somebody in a rental community, I want you to think about the impact that this kind of lawsuit can have on housing policies in your community. And again, ignorance is no excuse. Ignorance is no excuse. If you're running a rental property business, it doesn't matter if it's Michigan, if it's Georgia, if it's Nebraska, if it's Oregon, if it's Washington State, Washington, D.C., it doesn't matter. Ignorance is no excuse for violating the law. So let me pause because I see your comments coming in, and please keep those comments coming in. I am going to share some tips for landlords. I'm going to share some tips for tenants on today. I like that you said ignorance is expensive. Absolutely. You get it. Absolutely. So now let me share some tips for landlords, and then I'm going to get into my tips for tenants, because I want you as a property manager, as a housing provider, to know and understand this. Here's your first tip on today. If you are running a rental property business, please make sure that you ditch the one size fit all. All right. If that is your policy, please ditch it. They are definitely lawsuits. They are lawsuit magnets. You're setting yourself up. There's not a cookie cutter. There should not be a cookie cutter policy in place. One size does not fit all. You have to know and understand the law. Here's your second tip as a housing provider. You always want to make sure that you create make sure that it is in writing, because if it's not in writing, you cannot enforce something that does not exist. And if, let's say, for instance, someone comes to you with a proposed complaint or file a lawsuit against you, you want to have your policy, your practice in writing, because that is your best protection. People can say anything, but it's not what you know, it's what you can prove. And so you want to have something that is clearly written, that is explainable, and you always want to revise it as necessary, because the laws are changing. It may require your policies and your practices to change. Here's my third tip for landlords on today. Consider the nature, consider how severe that case is or was, and then also consider the timing of the offense, because all those things do matter. Now, I know that I said I have three tips for you on today, but perhaps I'm going to give you 2 extra more. So here's your 4th tip as a landlord. Document your decision-making process for every applicant. So for those of you who use property management software, you have you should have notes. You should have a guest card online in your property management software. But for those of you who don't, maybe some of you have a manual process. Maybe some of you use Excel or any other software program to take notes. Always keep documented records of each applicant. So for instance, let's say you have someone who came in today. Maybe document Susie Jane came in today to submit an application for our 2-bedroom. We conducted the background check. Susie Jane had a felony record from 18 months ago. You just want to document, right? So that you can keep a record of each person in case something comes up. So let's say, for instance, it's a fresh record, right? That allows you to not be able to rent, right? You have to, again, know what the laws are to know what you can and cannot reject, but always document it so that you can go back and look at those records so that you could defend why you rejected the application. All right, here's my 5th and final tip for landlords on today. You want to consult with your local landlord and tenant attorney. Make sure that you speak to someone who is knowledgeable about these type of laws, because again, what you don't know can and will hurt you. All right, so let me share some tips for tenants on today. One of the things that I always tell tenants is this: know your rights. Know as a tenant, know and understand that blanket bans such as this policy here, whereas let's say you are submitting an application, you're interested in a rental community. The landlord says that Maybe you have a record from 12 years ago. This landlord will tell you, oh, well, we don't accept felonies at all, right? If you know your rights, you know that a blanket ban may be a violation of fair housing laws. Always, 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 as a tenant, please keep documentation of every rental property that you tour. You want to document the date that you call, who you spoke to, the time. You want to document if you took a tour, if you went to the property, did they receive you? Were they professional? Were they courteous? Did they seem like they were discriminating? Did they give the appearance that they were disrespecting you? You want to document everything. You want to also document if you have been rehabilitated. Okay. You want to record and maintain all of that information. Okay. Any programs that you've gone to, that you've gone through, the help that you have gotten, you have definitely done yourself a good service with being rehabilitated, but you just want to make sure that you document it. Here's my third tip for tenants on today. Please be upfront about your housing screening process. Well, when you're going through your housing screening process, be upfront about your record. Be upfront with that landlord, the property owner, so that they'll understand a little bit about you. Here's why I always recommend that. Some owners will take a chance on you, although you have a record. How do I know? Because I've done that. I've been in this industry for a long period of time. I've managed well over 12,000 rental properties, right? And there have been applicants who came through with a record, right? And I gave them a chance where possible. And so please always be upfront and honest, because if you're honest, now that's not to say that everybody's going to make an exception. But I can almost assure you that if you are lying, if you're falsifying information on your application, you're trying to hide it, sometimes that can backfire, and you definitely don't want that to happen, right? And so be honest, be upfront, and be okay to have those extremely uncomfortable conversations. Sometimes those conversations can be extremely uncomfortable, but know and understand that it's always better to err on the side of caution, being upfront, honest, and integral. Because if that owner conducts a background check and find out that you have lied on your application, then that could be automatic ground for denial of the application. All right, so fourth tip for tenants on today. I always recommend getting a character reference. If you're working, get a character reference from your employer or your mentor. One of the things I would not recommend is to get a reference from your best friend, unless they are operating in some sort of professional capacity. Let me just park here for a second. I once had a young lady and I was giving her a break because she did not qualify. Like when I conducted a background check, she was just completely done. But I said, you know what? I'm going to give this young lady a break. She's a single mother. That resonated with me. I was once a single mother, right? And I was willing to give this young lady a break. I conducted the application, the background check, and in my screening process, it was revealed that this young lady had been evicted. Now, the eviction was not that long ago. So I called her up. I said, hey, we're just about completed. We're just about 85% completed with the application and screening process. But we do have a question because I see that you have an eviction on your record, but you did not note that on the application. So she assured me, oh, well, I worked it out with the landlord. They didn't actually evict me. I ended up staying at the property. So I said, okay, not a problem. Let me conduct a reference check with your current landlord. So I asked her for the landlord's name. I asked her for the landlord's number. Now, this young lady did live at a large apartment complex that I was very familiar with because one of my friends is part of the ownership team, right? So I knew exactly who they were. I knew where they were located. I could get on the phone like right now and call them and, you know. But anyway, I went through the process of asking the young lady that information. So she gave me a bogus name. I won't say a bogus name. She gave me a friend's name, right? She gave me the friend's name. I called the alleged landlord, right? I'm sorry, property manager. So I called the alleged property manager and I said, hey, this is Karissa. I'm calling from ABC apartment community. We're looking to rent to this young lady. And I just want to confirm as the property manager what her status is. I could clearly hear in the background that the young lady was in the car, right? So I called someone's cell phone. So she's like, oh, I'm new. I'm not in the office right now. And I said, okay, no worries. I said, well, what is your email address? I could email you the form. And if you wouldn't mind, please complete it and get it back over to us today. And she allegedly, because she was new, didn't know her email address. I said, well, what is I said, are you the property manager? She's like, yeah, I'm the new property manager there. I said, okay, well, who's the regional manager? She could not give me the name of the regional manager. I said, well, what is the office number or your corporate office number? She didn't have any of that information, right? And I knew that this was just a flat out lie. Like, okay, if you work for a company, you know the address, you know the telephone number, right? You should have your email address readily available to give to someone. But whatever, I'm just going on with the conversation just to see how far it's going to go. So I thank this young lady for her time. I follow up with the applicant a day later. I didn't call her right away because I wanted the girlfriend to call her to let her know that I did call. So I called that next day. I said, hey, we were not able to get the information we needed from your property manager yesterday. So she gave me somebody else's name and number, and I called right away. Would you believe the same thing happened again? So I called the young lady back right away. I said, listen, I just called the number that you gave me. We were not able to verify the resources. And because you have lied several times, we were willing to work with you. At this time, we're just going to move forward with the application process. So you'll get a letter, you'll get an email with the letter stating why we've rejected the application. So, of course, she was upset because she couldn't get a place. She had this eviction record and nobody would rent to her, right? And so this is what I tell applicants. Be upfront and be honest, because sometimes people, such as myself, where possible, might be willing to give you a break versus you flat out lying. You're just going to ruin all of your chances of getting into a place and get back on your feet. So this young lady, the applicant, she ended up calling me, I think maybe a month later, maybe like 3.5, almost 4 weeks later, to see if the apartment was still available. And I recognized the name and I told her, you know, I do regret to inform you that we've leased up all of our apartments. We don't have any vacancies. And she was like, well, I know you probably don't remember me, but you conducted the background check and I gave you someone's name. And I just want to apologize and to tell you that I'm so sorry. And I accepted the apology. I accepted the explanation. But at that point, even if I had something available, it was just not the best time for this young lady. So always be upfront as a applicant. Please be upfront. Here is my fifth and final tip for tenants on today. And then I'm gonna get into the money portion of how much and why this lawsuit could cost in the range of $1 million. You always, as a tenant, as an applicant, you always want to promptly, I should have indicated that, promptly report any type of discriminatory practices. You want to make sure that not only are you recording it, but you report it to your local fair housing office. You can report it to HUD. You can report it to your local fair housing office. You can report it to housing agencies if there's some sort of, there are a lot of housing advocates throughout multiple states and cities and jurisdictions. So just find out who you can report complaints to and definitely do that. But you want to make sure, like I said a little earlier, that you have documented everything. Make sure that you have it in writing. Make sure that you have your proof so that you can provide it when necessary. Let me pull up, give me 1 second. Let me pull up the money portion because I want you to understand just how severe this case is and why things are happening behind the scene and how it is impacting the rental community. It's impacting rental businesses everywhere. All right, so give me 1 second as I pull that up because I want to provide a breakdown. Let me get that on the screen for you here. Give me 1 second. All right, so when it comes to penalties from HUD, so let's say that in this scenario, HUD fines the landlord in violation of fair housing laws after conducting a formal investigation. Well, this can cost up to $16,000 for the first offense. It could cost up to $65,000 for repeated offenses. So in situations where this is not the landlord's first time, okay? So the first time, 16,000, but after that go round, it can cost up to $65,000. Now, let's just say that the lawsuit um, comes about from the denied applicant, right? So in this situation, the applicant sues for discrimination, alleging emotional distress and loss of housing opportunities. So the cost for damages for emotional distress, economic loss can range from 25,000 up to 150,000 plus attorney fees. Here's another category, a class action lawsuit. So you have, in a situation like this, you could have multiple applicants come forward claiming that the landlord screening policy discriminates against individuals with criminal records. And settlements for class action lawsuits, it could reach somewhere in the range between $250,000 to $1 million or more, depending on the number of claimants. Then you have the category of legal defense costs, whereas the landlord hires legal representation to fight discrimination claims. So in a situation like that, an owner obviously cannot represent themselves in court. They have to fight it legally with a landlord and tenant attorney. Attorney fees for fair housing costs could range from $10,000 to $100,000 or more, just depending on how complex that case is. Another category, settlements before trial. So to avoid trial, sometimes landlords might agree to go to settlement with the complainant, and this could typically cost anywhere from the range of $15,000 up to $100,000 just for settlement. Let's say you have a tenant who might be in some sort of housing subsidized program. If the landlord participates in a federal housing program, violations such as this could result in losing eligibility to continue to rent in that program to receive that income. A loss of steady income from some sort of housing subsidy program, that could total $10,000, $50,000 annually per unit, just depending on that rental rate. Now, there also could be court ordered compensation, whereas the court orders the owner to provide compensation for loss of housing opportunity, right? That also could include relocation costs. And that could range from $30,000 up to $300,000, just depending on the specifics of the case. Then you also have civil rights organization, right? They could file lawsuits. Whereas, let's say, for instance, remember I talked about the organizations who advocate for housing equality. They could file a lawsuit against an owner for a practice that harms protected groups. So these numbers can continue to climb through the roof and beyond. So in a situation like that, it could be a settlement, it could be a judgment that could range from $50,000 to $500,000. Then let's say there is some sort of compliance monitoring. Part of the settlement, the landlord may be required to undergo fair housing training and audits. Those monitoring fees, that can range from $5,000, $25,000. And so the list could go on and on and on. And so something like this, it could cost well over 1 million, 1 billion, really, because there is no limit on, I think it just really depends on how severe the case is. If there are multiple tenants, if there are multiple prospects, if it's multiple applicants that's involved, like there's really not a max on situations like this, which is why it is so important that you know and understand the law. So I hope that this information was helpful. And again, although this situation did happen in Michigan, it is not isolated to just that jurisdiction. Last week, I shared a situation out of DC. The week before that, it was another situation in the DC metropolitan area. I've shared stories and lawsuits out of New York, Georgia. The list goes on and on and on, unfortunately. I shared a lot of information for tenants on today. I shared information for landlords as well. Let me come to the comment section. Hello, Adam. Thank you so much for tuning in. Hello, Preacher. Thank you so much for tuning in, and happy marvelous Monday to you. I shared quite a bit today because I wanted you to know and understand how these type of impacts do weigh heavily on rental communities. So listen, this conversation is just too important for one session. I'm encouraging you to join me each and every Monday right here. I'm on Facebook, I'm on YouTube, I'm on LinkedIn at 7:30 p.m. Eastern Standard Time. Listen, if you have found this information helpful or valuable, please share it with someone else. Drop an emoji, a house emoji in the chat if you're going to be back next week, because next week I'm going to share another segment. And don't forget, please make sure to subscribe to my YouTube channel. There you can find me at Landlord Lyfe, and tap that notification bell so that you'll be the first to know when I'm live and when I am online. And if you're watching the replay, comment below. As a matter of fact, let me know what your biggest takeaway was from this segment today, because I would like to know. Today's discussion, I'm going to do a part 2 next week. All right. So I want your feedback because your perspective is definitely important, whether you are a landlord, whether you're a tenant, or you know someone who is. Your impact is, it's valuable. Your feedback is valuable. And so please make sure that you share with me in the comment section, what was your biggest takeaway today? And I did ask 3 questions a little earlier. I asked a question as to whether or not landlords should be required to consider individual circumstances instead of a blanket ban. I also asked how can landlords rather balance safety with fairness in tenant screening? Because it is important, right? Everybody needs a place to call home. And so how can landlords balance their policy and their practice? And then third and final question that I asked on today was, what impact could this lawsuit have on your housing policies in your rental communities for those of you who are landlords? All right. That's what I wanted to share with you on today. My time is up, and I absolutely thank you for yours. Thank you for joining me today. Let me share my email address. So if you need to reach out to me when I'm not live, when I'm not on the air, that's my email address there at the bottom of the screen. You can email me, info@landlordlife.com. I hope that you join me next week right here. I'm live on Facebook, YouTube, and LinkedIn. Thank you again for tuning in. I'm Karissa Spann, the landlord and tenant expert. It's been a fantastic pleasure having you join me live today or watching the replay. I'll see you all next week. I'm going to say bye for now.